Georgia versus Terrell and go right into court in Florida where closing arguments are happening.
Premeditatedly and torturously killed her, had a plan. He had a plan and he had a goal. And she was part of that plan. And his goal, his end game, is this. It's this trial. Jennifer Fulford is dead because the defendant wanted an opportunity to come into a public forum, take a witness stand, not once, but twice, and tell the world about the people and the entities that he erroneously believes have wronged him. Jennifer Fulford is dead because the defendant accomplished his goal. And that accomplishment warrants the imposition of the death penalty. Before I start talking about the aggravators that the state has to prove and about the process of the death penalty, I want to go back a little bit. And I want to talk to you a little bit about the differences between the guilt phase of a trial and the penalty phase of a trial. And I bring this up because this is actually something that we talked about quite a bit during the jury selection process. If you'll recall, when we brought each one of you in here individually, we talked to you about the death penalty. And for quite a few of you, if not all of you, we talked about how the penalty phase and the guilt phase are two completely separate processes. And to a certain extent, that is accurate. But in other ways, it's not entirely accurate. And I want to make sure that we're all on the same page about how these two parts of the trial relate and are interrelated. Because you can never forget that it is one trial. It is one state. It is one defense. It is one judge. And it is one jury. And although they are separated, the evidence that came in during the guilt phase is applicable during your consideration and your deliberation in this penalty phase. All of the physical evidence that came in not only during the penalty phase, but also during the guilt phase, will once again go back into the deliberation room with you. Some of it can't, the weapons, the biohazards, but if you want to see that stuff, you can always ask for it. But the important thing to remember is everything that you heard during the guilt phase, everything that you saw, the testimony of the witnesses, your own notes, and your own independent recollections, all are applicable in your consideration of the penalty phase. And there's another thing I want to touch on, that there are some differences between the guilt phase and the penalty phase as it relates to the law. Now, just as we did in the guilt phase, when we're done with our closing arguments, the judge will read you jury instructions. There's a copy right here. And that's the law that is applicable to the penalty phase. And what you're going to hear is that there are aggravators that the state has to prove. And it's different than what the state had to prove during the guilt phase. During the guilt phase, we had to prove elements of crime. And I'll use an example, first-degree murder. Obviously, that's what we're here for. You're considering whether he should get the death penalty for his conviction of first-degree murder. I told you during the guilt phase that first-degree murder can be proven in two ways, felony murder and premeditated murder. When we start talking about the aggravators, you're going to hear that there is an aggravator called during the course of a felony. The murder was committed during the course of a felony. And at first glance or first blush, you might think, well, that's exactly like felony murder. but you have to listen to the law. When you hear one of the aggravators is what we call cold, calculated, and premeditated, there's that word premeditated murder, you might think, okay, those two things probably mean the same thing. They don't. The definition of premeditation in the guilt phase is different than the definition of premeditation here in the penalty phase. I bring this up and I point this out because while you're sitting here listening to me do my closing argument, you might hear me say some things that might seem, didn't she say something a little different last time we listened to her talk? And the answer to that is yes, but there's a reason for it. The reason for it is because what we have to prove to you is different. The law is different. So for example, in the guilt phase, I talked to you about how we can prove premeditation in an instant. That it didn't matter when he actually decided to commit this murder. Was it when he bought the knife? Was it when he knocked on the door? Was it when he was in the fields? Didn't matter to prove premeditation in the guilt phase. It matters here. When he decided to kill her matters here. What I will tell you right now is he decided to commit a murder at least, if not before, September 16th of 2017. That is what the evidence supports. But we'll get to that. So please, as you're deliberating, please remember that while they are one part of an overall trial, two parts of an overall trial, there are differences. You have to rely on the evidence and apply it to the penalty phase, and rely on the law and apply it to the penalty phase, and rely on the arguments of counsel and apply it to the penalty phase. Now I want to talk to you specifically now about the death penalty. Each and every one of you swore to follow the law. You've sworn, at this point, kind of lost count, maybe at least 3, if not 4 times. There were 3 stages to jury selection, and then, of course, when you were actually selected as jurors, you all swore to follow the law. In following the law, you all swore that you would consider the imposition of the death penalty. You all swore that you would follow the procedure set out by the Florida legislature, because the death penalty is the law in the state of Florida. You all swore that even if generally you're not a fan of the death penalty, or you're opposed to the death penalty, or the opposite, if you believe very strongly in the death penalty, that you would fairly consider all of the evidence and all of the law, and when you walk back in that deliberation room, you will follow the law as it's set out in these instructions, and you will consider fairly the imposition of the death penalty. It might have seemed theoretical back when we were talking about it, when you all had to take our witness stand and talk to each one of us. It's not theoretical anymore. Now, what this law says is that you have to look at this murder. And you have to look at this murderer. It is not your role to compare this crime to other crimes or other murders. It is your role to consider the aggravating factors, the mitigating circumstances, weigh them, and decide if this crime and this criminal deserve it. Now, there's one last thing I want to talk about before I start talking about the process of considering the death penalty. And that is it's another thing that came up quite a bit during jury selection. Now, this phase, I've mentioned there are differences between the guilt phase and the penalty phase, and one of the differences is that I don't get back up here. You'll recall in the guilt phase, the state got to do an initial closing, and then we got to do a rebuttal closing. after the defense had their opportunity to talk to you. That's not going to happen today. Today, this is the only chance that I have to speak with you. So in some ways, I have to anticipate the argument that Ms. Simmons will make when she gives her closing argument. Based on experience, based on things that have happened during the course of the trial, I'm trying to anticipate things that I believe she would say. If I end up I'm wrong, I'm wrong. But one of the things that was talked about in most, if not all, jury selections was this concept of bullying in the deliberation room. I think that was the word that was used, bullying. And all of you were asked, most if not all of you were asked, would you be able to stand your ground? If you believed you were right, would you be able to stand your ground? Not to succumb to somebody else? On one hand, I completely agree with that. Bullying, as the word is commonly used, is absolutely inappropriate. Nobody should be yelling. Of course, there should be no physical violence. Nobody should be yelling at each other. There needs to be calm deliberation. But this idea that you would stand your ground, I have a fundamental disagreement with that concept. And my fundamental disagreement with that concept is that it suggests that you shouldn't deliberate. Deliberation by jurors is the fundamental concept upon which our judicial system is based. Our judicial system completely fails if our jurors do not deliberate. You are not a jury of 1. You are a jury of 12. When you go back to deliberate, you will not go into 12 separate rooms. You will go into one room that I'm sure by this point you're very familiar with. And you will deliberate. You will talk about it. You will express your opinions. You will express your views. That's what our entire system of justice is based on. Now, I'm sure you guys have been sitting here for about 2.5 weeks now, listening to the guilt phase, listening to the penalty phase. It's human nature that you've thought about it. I'm sure you've all followed the judge's instructions and not talked to anybody or talked to each other. But it's hard to imagine that you haven't thought about it in your own head. And when you walk back into the deliberation room, you might already have, especially once you've heard the judge's instructions, you might have formulated some thoughts and some opinions. You might even have already made what you believe is going to be your decision. But when you go back there, what the law requires is that you deliberate, is that you listen to each other, is that you consider other points of view. And I don't care which side of this you're on. It doesn't matter to me. It doesn't matter to me if you're sitting here right now and thinking, I want to impose the death penalty. Or if you're thinking, I don't want to impose the death penalty. Either side. It's called justice. You have to go back there and deliberate. Once you've deliberated, once you've listened to everybody else's opinion, once you've considered the evidence, the testimony, the argument of the lawyers, the law as explained to you by the judge, it is then that you reach your decision. And if you get to the point where you have decided and you believe further deliberation would be futile, that's when you've reached your verdict. That's when you vote. And that's when you decide. And that's not standing your ground. You need to be open to others' opinions and views and know that they can change your mind, and that's okay. So please remember this when defense counsel is talking to you about this concept of bullying. At its core, it is fundamentally against the United States Constitution. One last thing before I start talking about the aggravators. I've talked a lot about how you get to consider all the testimony that has been presented to you, all of the evidence. There is one witness that I want to highlight, one person that I want to talk about before I move on, and that's him. You've heard from him 3 times in this trial. You heard during the state's case, you heard his statement to law enforcement. During the defense case, you heard him testify in the guilt phase. And then, of course, here in the penalty phase, he testified. You have 3 statements from him. Here's what I submit to you. I will be basing my closing arguments on nothing that he has said, ever. I will not rely on anything that he said to law enforcement or anything that he said from that witness stand. And I will tell you why. I don't believe that I can stand here and ask you to believe the parts of his testimony that support my argument, but don't believe the parts of his testimony that support theirs. I don't believe that's right.
Objection to personal opinion.
Sustain the objection to the form.
Personal opinion.
I'm sorry, I still didn't.
Personal opinion.
It would not be justice to talk out of both sides of my mouth. There are aspects of his testimony that absolutely support, if not prove, some of the aggravating factors that the state has to prove to you. Just like there are aspects of his testimony that support mitigating circumstances. The law allows you, as the jurors, to believe some, all, or none of his testimony. I will leave that up to you. That is your discretion. But as I make my arguments to you, I will rely on the testimony of the other witnesses and the evidence that has been presented, so that I do not ask you to believe some, but ignore the parts that aren't good for me. All right, so let's talk about the death penalty. The death penalty in the state of Florida has 5 steps. Now, again, another difference between the guilt phase and the penalty phase. When you went back to deliberate during the guilt phase, it didn't matter. We didn't tell you what to do. We told you pick a 4-person, deliberate, and give us your verdict. You could have started with count number 4. You could have started with count number 2. You could have done anything you wanted to do. But that's not the way this works. The jury instructions, and really a better source is the verdict forms, are going to tell you exactly what you have to do when you go into the deliberation room. The defense has a very handy chart that I believe she's going to use during her closing argument. It's going to tell you exactly how you have to deliberate and exactly the step-by-step process you have to take, because it is what is required by the law. There are 5 steps. They are listed A through E. And when you go back there, you're going to get the jury instructions and you're going to get the verdict form. Of course, if you have any questions during your deliberations, you're going to ask. But what I would recommend to you is read through the verdict form, because the verdict form is actually a much better source for how you should conduct your deliberations. It tells you what step A is and what you need to do, and then do you even move on to step B? Yes, you move on to step C, D, and E. So, step A, step 1, is the consideration of aggravating factors. The state has to prove to you at least one aggravating factor exists beyond and to the exclusion of any reasonable doubt. It has to be a unanimous decision. So again, unanimously, you all have to agree that one aggravating factor exists. And what you're going to do is you are going to see on the verdict form there are 7 aggravating factors that are listed. And you are to consider each one. So you would look at what aggravating factor number 1 is, you will discuss it, you will deliberate it, and then you will vote on it. And if you unanimously agree that the state has proven that aggravating factor beyond and to the exclusion of any reasonable doubt, you check yes, There's a yes or no. You check yes, and you move on to aggravating factor number 2, and so on and so forth. Obviously, if you deliberate and you decide that you decide that unanimously this has not been proven, that you haven't decided unanimously it's been proven, you would check no. So let's talk about the aggravating factors. The legislature has laid out 16 aggravating factors, and in this case we have alleged 7. We have alleged to you that 7 aggravating factors exist. And remember, you have to consider this case, these factors, and this defendant. Because that's what aggravating factors are. They are circumstances that increase the gravity of a crime or the harm to the victim. In the guilt phase, the state never has to prove why a crime was committed. That is not an element of any crime ever, why something was done. In a penalty phase, that's a big part of what we do. A big part of these aggravators is proving to you why the defendant did something. There are also the aggravators that establish how, the harm to the victim. And then there are aggravators that are based on the defendant and his background. And that's where I'm going to start. So one of the aggravating factors is that the defendant was on felony probation, that he had a felony conviction, and he was on felony probation at the time the crime was committed. The state has absolutely proven this aggravating factor beyond and to the exclusion of any reasonable doubt. One of the things that is in evidence is what's called a J&S. We call it a J&S. It's a judgment and sentence. It looks like this. It's going to go back in the deliberation room with you. And what this is his judgment and sentence for his prior bank robbery. Bank robbery with a deadly weapon. A dangerous weapon. Dangerous weapon. And when you look at that document, you will see, you can look through it, and you will see that he was to be on 5 years of probation after he was released from prison. You've heard testimony that he was released from prison in May of 2017. And of course, these crimes occurred in September of 2017, only 4 months after he was released from prison. So if he had to serve 5 years of probation, and this is only 4 months later, the evidence certainly supports that he was on probation at the time of the offense. Now, I am guessing that the defense is going to argue that we have not established this aggravating factor because no witness said he was actually on probation on September 27th of 2017. Well, remember, evidence can come to you either from the witness stand or from documents and physical evidence that has been placed into evidence. And you can use your own common sense to interpret that evidence. You heard about his probation officer. You heard from Mr. Estremera when he came in here during the penalty phase, the employer who said, I met with the probation officer. That was in September of 2017. The evidence absolutely proves that the defendant has a prior felony conviction and that he was on probation at the time the crime occurred. So when you go back to deliberate, you should check the yes box for unanimously proving this aggravator. The next aggravator also has to do with the defendant and his background, and it has to do with that same crime, that bank robbery with a dangerous weapon. The next aggravator is that the defendant has a prior violent felony, and that violent felony has to include either the use or the threatened use of force. So he either had to use force to accomplish that crime, or he had to threaten the use of force. You may have been wondering...
To the statement of the law regarding force.
I'll sustain the objection to the form of the argument.
Violence. Threatened use of violence. Apologize. So the use or the threat of violence. been wondering during the penalty phase why we put on 3 witnesses of another crime. We put on 3 witnesses who talked about a prior bank robbery. The reason we had to do that is because the law does not allow you to speculate about whether or not violence was either used or threatened to be used during this prior felony. So even though it is a bank robbery with a dangerous weapon, and the crime itself certainly seems to suggest violence or the threat of violence, we can't assume that just based on the crime itself. So we had to put on witnesses to establish for you, beyond a reasonable doubt, that the actual facts of the crime that he committed involved the use or the threat of violence. You heard about how he walked into a bank. He went into a room where you open an account under the pretense of opening an account, and he handed the bank employee a multi-page letter. One of the employees even testified, I only had to read the first couple of lines to know exactly what was happening. You heard about how he had a bag with him and a device, and how he had something in his hand that he was certainly suggesting was a trigger for a bomb. You heard from those 2 witnesses, the 2 bank employees, about how they believed they were in danger. How this threat of violence, being blown up by a bomb, was enough for them to go get the money and give him a substantial amount of cash. Bank robbery with a dangerous weapon, where the dangerous weapon is a bomb, is threatening the use of violence. What does not matter is that the bomb was fake. That is irrelevant. If somebody walks into a store with an unloaded gun but threatens the clerk, that is the use of violence, even if they couldn't actually shoot the clerk. Because you look at it from the victim's perspective.
Objection to statement of the law, Your Honor.
I'll sustain the objection to the form.
Okay. Was the victim threatened by this action? The answer to that is yes. Therefore, the state has proven to you, beyond and to the exclusion of any reasonable doubt, that the defendant has a prior violent felony that involved the use or the threat of violence. Now, the next aggravating factor that we have alleged is that this crime was committed, meaning the murder of Jennifer Fulford, was committed during the course of a robbery. This one should be relatively easy because you have already found that the defendant committed robbery. In your verdict from the guilt phase, you found him guilty of murder, carjacking, robbery, and kidnapping. So you have already found that he committed a robbery, and you have already found that she is dead. We know that that murder happened during the course of a robbery. However, let me be very clear about something. The defendant's original motive was not robbery. The defendant's original intent was not robbery. I want to take you back to a moment in time that you heard about in the evidence. That moment is 11:32 on September 27th. The moment when he knocked on the door. At that moment, he intended to kill Jennifer Fulford. That was his plan from the very beginning. Again, it was a plan that he developed back at the beginning of September when he didn't get fired from his job, when he, as you heard from Mr. Estamera, was asked to leave. And remember, the defendant is a narcissist. It is all about him. It is always about him. It is always about him getting what he wants. And when he wasn't allowed to stay in the temporary housing that had been set up for him out of the goodwill of Mr. Estamera didn't fire him. He asked him to leave because he'd been paid. Go find a place to live. You have money now. But that's not okay with him. Because he wasn't in control. He wasn't in authority. He was being told what to do, and he didn't like it. So he left. And he demanded his last paycheck. And he showed up on September 15th, and he got his last paycheck, and he went to a Walmart the very next day, and he bought the supplies he used to murder Jennifer Fulford. It is that simple. He planned to do this the beginning of September. So going back to this aggravating factor that it was during the course of a robbery, the robbery was a secondary gain. His intent was murder. Because his cold, calculated, and premeditated plan, he couldn't get to his end game of being able to take that witness stand and being able to rail against the world and getting the attention that he wanted to get from the crime that he committed unless he went big. Go big or go home. He went big. So yes, there was a robbery, and yes, Jennifer Fulford died during the course of the robbery. So you can absolutely find that that aggravating factor has been proven beyond and to the exclusion of any reasonable doubt. The next aggravating factor is what we call pecuniary gain. Money. He was motivated, what the law says, that he was motivated, at least in part, by financial gain. In other words, he committed this crime, at least in part, to get money. Again, I submit to you that his motivation, his dominant motivation, was murder. However, was he motivated, at least in part, to get money? Absolutely. Not once, not twice, but 3 times he went to an ATM machine. 2 times he was successful in getting money from her account. Nothing wrong from his perspective of benefiting a little bit. So was he motivated, at least in part, by money? Absolutely. That's all the law requires. Motivated in part. Now, there's something I need to explain about the law here in Florida, and that is that these 2 aggravators that I have talked about in the course of a robbery and pecuniary gain, if you find that both of these aggravating factors have been proven beyond and to the exclusion of any reasonable doubt, they merge together. So what that means is that 2 aggravators, because they are based on the same set of facts and circumstances, meaning, because robbery was his way of getting money, and pecuniary gain was basically about getting money. So because those 2 aggravators are so interrelated, if you find that both of them have been proven, you need to consider them as one aggravator. Okay? It is not 2, it is 1. So in other words, if you find that the state has established all 7 aggravators beyond and to the exclusion of any reasonable doubt, when you are doing your weighing, you are actually weighing 6 aggravators, because those 2 aggravators merge into 1. They don't get any extra weight because they're 2 in 1. You give them the weight that you believe they deserve as one aggravator together. Now, the next aggravating factor is what we call the avoiding arrest aggravator. And what this means is that the defendant's, what the law says, is that the defendant's predominant motive was to avoid arrest. And in this case, the way he did that was by witness elimination. So you can think of this as the witness elimination aggravator. So was his predominant motive in killing Jennifer Fulford to avoid arrest? The state's going to leave this one in your discretion. As I've said to you before, I will not rely on anything that was said by the defendant in my closing argument. It's up to you if you decide on the statements he made about why he killed Jennifer Fulford. Is there evidence in the record to support it? Absolutely. But the state will leave this one to you. So that's 5. Now we're down to the last 2. The next one I want to talk to you about, this goes to the how. This goes to the how he committed the crime. It's called heinous, atrocious, or cruel. We call it HAC for short. What's important to notice, though, that it is an or. Heinous, atrocious, or cruel. Now, the judge will define for you what those words mean. I want to highlight one aspect of this instruction, though. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to Jennifer Fulford. If he had opened the door and shot her, that's not HAC. But of course, that's not what he did. And what you really need to look at and examine in the evidence is how this was torturous to Jennifer Fulford. You have to consider, as difficult as it may be, you have to consider what she went through and what she experienced on September 27th. There's a knock at the door. She opens it, and she's bound at her feet and her wrists. That is common sense that that's what happened. Because you know from the alarm records that he had to go upstairs to get the comforter. And as I talked about in my closing argument before, she's not going to just stand there. She's not going to wait at the bottom of the steps while he goes. So common sense tells you that as soon as he got into that house, he had to tie her up using the zip ties and the duct tape that he bought and that you saw on her body. "22 minutes. 22 minutes he's in that house. And she's left to wonder, is this just a robbery? Am I going to be raped? Am I going to be killed? Well, one of those questions was answered at the end of the 22 minutes. It wasn't just a robbery. Because he picked her up, wrapped her in the blanket, and carried her out to the car. I submit to you that that is what had to have happened. Because he had to have put the duct tape around her ankles in that house. Otherwise, when he goes upstairs, she runs away. So he had to have put the duct tape around her ankles. She can't walk to the car if her ankles are duct taped together. He had to carry her. 16 minutes in the back of the car before he gets to the ATM. 16 minutes under a blanket, not knowing what is happening, where she is going, what's going to happen to her. It's terrifying. He gets back in the car after the ATM 1 hour and 24 minutes later is when he gets to the murder site. When he gets to Fenton out there near Disney. By the time he got there, she had been in the back of that car for 1 hour and 40 minutes. "17 minutes. 17 minutes is the amount of time the defendant was at the murder site. We know that based on the phone records. Jennifer's phone records hitting off the towers. 17 minutes. I submit to you that what the evidence supports based on Jennifer's condition out in that field when she was found is that he opens up the back and he carries her out. It wasn't that far. The testimony was somewhere around 30, 40 feet. That's 10 yards. It's a first down. He can carry her for 10 yards. Remember, his legs were all scraped up. Now, what the defense is going to argue to you, and anticipate, is that we have no way of knowing whether Jennifer Fulford was conscious at the time she was taken into the field. I submit to you that we absolutely do know. The reason why that is important is because the HAC aggravator does not apply if somebody is unconscious. So, for example, if when he walked in the house, he punched her, knocked her out cold, and she never regained consciousness, HAC would not apply. That's what the law holds. However, the evidence does not support that that's what happened. In fact, the evidence supports the exact opposite. You know from Dr. Stephanie's testimony, the medical examiner, you know from his testimony that she had the duct tape wrapped around her head in multiple layers. You saw, there are pictures of duct tape in evidence. So you know that there were multiple layers around her head. He told you, Dr. Stephanie, that once that duct tape was applied to her head and covered her nose and her mouth, that is when she would have started to asphyxiate, when she wouldn't have been able to breathe. If somebody is unconscious and you have a knife that you can kill somebody with, why do you need to wrap duct tape around their head? It's unnecessary. It defies common sense. You also know that because of the amount of time she would have been alive once the duct tape was applied, you know that duct tape had to have been applied out in that field. Because if he had applied the duct tape earlier, she's dead. And why would you stab a dead body 7 times? Again, it's unnecessary. She's already dead. You accomplished your goal. So what the evidence supports is that she was alive and she was conscious. And why does he duct tape her head? Because she was screaming. Because she was terrified. Because now she's out in the open. Now she knows. The person who has kidnapped you doesn't bring you to an open field in the middle of nowhere to do anything other than murder you. She knew. She's not going to just sit there and take it. So of course she starts screaming. So he starts rapping. Now the medical examiner told you that she died in one of 2 ways or a combination of both. She died from the asphyxiation because she couldn't breathe because of the duct tape, or she died from the stab wounds. What I submit to you, the evidence supports, is that when she got to that location, out in that field, after he carried her out to that field, and he couldn't take her screaming, he starts wrapping her head, and then he starts stabbing her. Now, the defense is going to talk about Dr. Stephanie's testimony and the testimony during the guilt phase about how somebody can get stabbed in the heart in just the right location, that it cuts off the electrical components of the body and you die instantly. Do not forget Dr. Stephanie's testimony from the penalty phase that is not what happened to Jennifer Fulford. Dr. Stephanie, during the penalty phase, told you that yes, there is that area of the heart, but that is not where she was stabbed. She was stabbed in her heart, but she was not stabbed in the area of her heart where it would have caused the instant death. Jennifer Fulford did not die instantly.
Objection, Your Honor, facts on evidence.
Members of the jury, this is closing argument. It's up to you to determine what the evidence shows in this case.
She did not die instantly. He told you that area is on the left and she was stabbed on the right, or vice versa. That's what Dr. Stephanie told you. She did not die instantly. Dr. Stephanie told you that she would, once the duct tape was wrapped around her head, how long she would have been conscious before she went unconscious before death because she wasn't breathing. Really kind of depended on who she was. That can be different. You know, if somebody is a swimmer and can hold their breath for longer, maybe they could hold their breath for longer. But the average person, it's going to be a couple of minutes. About a minimum of 2 minutes. He said something similar about the stab wounds. That once she was stabbed and started losing blood, at some point she's going to lose consciousness because of the loss of blood. And again, that can take a varying amount of time, but a minimum of about 2 minutes. Jennifer's sitting out in a field. She's got duct tape around her head. She cannot breathe, and a knife is repeatedly piercing her body. She's feeling pain. Not once, not twice, not 3, not 4, not 5, not 6, 7 different times. Repeatedly, over and over again, the pain of the knife entering her body.
Objection to facts on evidence.
Members of the jury, this is closing argument. It's for you to determine what the evidence shows in this case.
You heard about 7 stab wounds. 5 to the front and 2 to the back. Two minutes. If there had only been the stab wounds, she would have bled out and lost consciousness in a minimum of 2 minutes. If there had only been the duct tape around her head, she would have lost consciousness and died of asphyxiation in a minimum of 2 minutes. That's 2 minutes during which Jennifer Fulford contemplated her impending death.
Objection to facts on evidence.
Members of the jury, this is closing argument. It's up to you to determine what the evidence shows in this case.
We throw around 2 minutes like it's nothing. Somebody says, hey, are you coming? Yeah, give me 2 minutes, I'll be right there. 2 minutes is a very long time. When you have duct tape around your head and you've been stabbed 7 times. That's how much time Jennifer Fulford had. Laying in the field, dying. If that's not heinous, atrocious, and cruel, if that's not torture, I don't know what is.
Objection to personal opinion.
Sustain the objection to the form.
There's one last aggravator, and it's called cold, calculated, and premeditated. Now this, we call it CCP for short. This is an and, cold, calculated, and premeditated. Again, the judge is going to read for you the definition of the words cold, calculated, and premeditated. I want to highlight one aspect of the definition of premeditated. The initial part of the definition of premeditated is the same as you heard during the guilt phase. However, there's another aspect to it. It says, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. So it's heightened premeditation. How do you know that this aggravator has been proven beyond and to the exclusion of any reasonable doubt? You know what his plan was. I don't have to go through it again. He gets the money. He buys the supplies at Walmart. On September 27th, he sees the FedEx guy leave. You know the FedEx package was picked up because it was inside the house. He had the murder supplies with him. Again, the defendant's plan, the defendant's reason for committing this murder was this, so that he could take that witness stand. He wanted the attention. He wanted the opportunity to rail against the world. And he's only going to get that if he goes big. So he went to an extremely affluent area and he picked his victim. And he takes her over to Disney. Look at the maps. He took the first Disney exit off of I-4. There was actually an exit closer to Fenton that he could have taken. He could have taken Sand Lake. But he didn't. He went to Disney, the world's tourist destination, where he knows that if a body is found near Walt Disney World, that's going to make news. That's going to be a big deal.
Objection to facts on evidence.
Members of the jury, this is closing argument. It's for you to determine what the evidence shows in this case.
The state is making arguments based on the evidence and inferences that can be drawn from the evidence and your common sense that can be drawn from the evidence. Why else would he choose there? Why would he drive an hour and 24 minutes? There was a purpose behind everything he did. This was a calculated plan that he had. There was a purpose behind every step he took. From buying the supplies to where he left the body, in broad daylight, in a field, not far from an extremely populated area, not far from the world's tourist destination. There was a reason for it. It was part of his plan. He wanted to get caught. It is that simple. He wanted to get caught. Everything he did after that was part of his plan. Using the ATM, not hiding his identification in any way, shape, or form. Using his own name to buy the train ticket. Standing in front of as many cameras as he possibly could on the buses, at the Publix, in the Amtrak train station, in the Amtrak train station up in Jacksonville when he just stands there for a couple of minutes looking at the camera. 2 days later, he uses the ATM after he checks into a motel in his own name and uses the ATM not too far away. He wanted to get caught, and he wanted to make sure that he was prosecuted, because that's the only way he guarantees taking that witness stand. Why else would he tell law enforcement where the knife is? Why else would he tell law enforcement where the keys are? Because he wanted to make sure he got prosecuted. He wanted to make sure that the state could prove this and that he would get the chance to take that witness stand. It was all part of the plan, and he accomplished it. The state has proven to you, beyond and to the exclusion of any reasonable doubt, that this murder was cold. It was calculated, and it was premeditated to a heightened extent. He knew exactly what he was doing and what he was trying to achieve in his actions. Now, once you have considered the 7 aggravating factors that the state has proven to you, the second step of the death penalty process is to look at the aggravators themselves and to vote on whether or not the aggravators themselves, without consideration of the mitigating circumstances, whether or not the aggravating factors themselves are enough to justify the imposition of the death penalty. The state submits to you that this is absolutely a murder that deserves the imposition of the death penalty. And when you consider all of the aggravating factors, you should have no problem unanimously checking off the yes box so that you move on to step 3. Continuing to follow the law. Step 3 is where we get to the mitigating factors. Now, defense counsel, I'm sure, is going to talk to you at length about the mitigating factors, so I'm not going to spend too much time on them. There are a couple of points that I want to highlight, though. You heard from multiple doctors. Dr. Pritchard, Dr. McLean, Dr. Woe. There were multiple mental health people who testified for you. You get to decide who you find more credible. I don't have to stand here and go through their expertise with you and what they testified to. It was just in the last couple of days. And again, I'm sure the defense counsel will touch on it. However, I do want to talk for a moment about Dr. McLean. And I submit to you, the state submits to you, that Dr. McLean's testimony lacks credibility. And here's why. Dr. McLean told you that much of her opinion, aspects of her ultimate opinion about the defendant's mental health issues and conditions, was based on self-reporting by the defendant. That there were aspects of things that he told her that she could not corroborate. There were things that she could corroborate, but there were things that she could not corroborate, and despite the lack of corroboration, she relied on those things in order to form her opinion. However, she also told you that she believes the defendant embellishes. He embellishes. She told you, she actually specifically referenced the blood pizza because she told you that she listened to his transcript from the interview with law enforcement and that she recalled the blood pizza part of it. And that was just an embellishment. Another word for embellishment is dishonesty. It's another word for embellishment. So Dr. McLean simultaneously told you that he is dishonest, but that she relied on the things that he said to establish her opinion. Take that into consideration when you're questioning her credibility. Another thing that she told you. She told you that, well, she gave you an opinion. She gave you an opinion about one of the mitigating circumstances. The mitigating circumstance that she gave you an opinion about was that the first-degree murder was committed while Scott Nelson was under the influence of extreme mental or emotional disturbance. That's at the time of the crime. That's at the time the crime was committed, he was under this extreme emotional disturbance. She opined that. She said, that is my opinion, that he must have been. Because he's got mental health issues, and he was homeless, and he hadn't been on his meds, presumably, and so he must have been. But she also told you that despite the fact she had 2 separate interviews with him, and despite the fact she talked to him for over 3 hours, she never bothered to ask him about what was going through his head at the time he committed the crime. If you're going to come into a court of law and offer an opinion about his mental state at the time he committed the crime, and you have an opportunity to ask him, why wouldn't you do that? Why? It goes to her credibility. Why wouldn't she do that? There are 2, what I will call mental health mitigators that are listed, 1 and 2. One is the one that I've already read for you, and the other one is that the capacity of Scott Nelson to appreciate the criminality of his conduct or to conform his conduct to the requirements of the law was substantially impaired. You heard a lot of testimony about his mental health. I am not going to stand here and tell you he doesn't have mental health issues. Dr. Pritchard told you prison didn't make him the man that he is today. He's been that man for a very long time. And his issues did not cause him to commit these crimes. I submit to you that you, the jury, are in the absolute best position, better than any doctor that took that stand, to judge his mental health at the time of the crime. You saw him that day. You saw him. You know what he had to do in order to get into the house. You know what he had to do once he was in there. You know that he had to drive the car and use the ATM and drive out to Disney. But you saw him after. And you can take that into consideration when you are deciding whether or not this mitigating circumstance has been proven. You can take into consideration what you saw with your own eyes. You know he parked the car at the Publix. You personally saw him walk in. He walks out. He gets rid of the keys. He gets on the bus. The man on the bus did not appear to have any emotional disturbance or be under any issues at that time. He was chatting with the guy in the seat next to him. Watch the bus videos. When he got off the bus, he said thank you to the driver. You saw him go to the Amtrak, go to the ATM, get his pizza. That is not a man who was suffering or under the influence of extreme mental or emotional disturbance. It was not happening. And Dr. McLean did not watch the videos, you did. The second mitigating circumstance, that he could not conform his conduct to the requirements of law or that it was substantially impaired, for the exact same reasons, among others, has not been established. This is a man who has been conforming his conduct for 25 years in prison. This is a man who was able to get out, get a driver's license, get a job. He was able to use the bus lawfully. He was able to drive the car. He prides himself in being able to conform his conduct. It's only when he doesn't get his way, or he perceives that he's not getting his way, that he purposefully doesn't conform his conduct. His mental health issues did not make him unable to know that stabbing somebody 7 times is going to cause her death, and that's illegal. He knew exactly what he was doing. So here's the thing about mitigating circumstances. Unlike aggravating circumstances, they do not have to be proven beyond a reasonable doubt, but they do have to be proven. When you are considering the mitigating circumstances, it is a 3-step process. Step 1, was it proven by a greater weight of the evidence? Only one of you has to find that. It is not unanimous. So when you're looking at the list, it'll say, does at least one juror find? And then it talks about the mitigating circumstances. So when you deliberate, you talk about it, and then you take your vote. If one person has found that mitigating circumstance has been proven, you check the yes. But if nobody thinks the mitigating circumstance has been proven, you check no. You have to do this 54 times. There are 54 mitigating circumstances that are in the verdict forms. The first 2, the 2 that I've already talked about, I submit to you, you check no, because they have not been proven. Because as you consider these aggravators and mitigators, never forget that step 1 is proof. And if it's no, you move on. If at least one of you says yes, then that person, because this is an individual determination, that person and that person alone has to then do step 2 and step 3. Step 2 is consideration. You have to give it consideration. What exactly does that mean? Well, you got to think about it. You got to talk about it. What does it mean to you? And then step 3 is how much weight do you want to give it? How much weight are you going to give that mitigating circumstance? And that is entirely up to you. You can give it no weight. You can give it a little bit of weight. You can give it some weight. You can give it great weight. There's nothing on the verdict form for you to indicate how much weight you're giving it. It's an individual, personal determination. But I want to give you an example. This is one of the actual mitigators. I'm not going to go through all the 52 other ones. One of the actual ones on here is that when the defendant was born, his mother had to go to a hospital, and he went to live with an aunt who had 3 other kids. That has been alleged as a mitigating circumstance. So step 1, has it been proven? Well, if you believe his brother James said, his significantly older brother said, yeah, when he was born, he had to go live with an aunt. I think James went living someplace else, and Bob went and lived someplace else. So James wasn't there, went to live with the aunt. So, and we heard testimony that the aunt had 3 kids. All right, so has that mitigating circumstance, what is actually written on the piece of paper, has that been proven? I'll say yes. It's a greater weight of the evidence. James testified to it. Okay? Step 2, consider it. All right, well, we didn't hear anything else. Was she a nice aunt? Was she a mean aunt? Did she love him like he was her own? We have no idea what happened to the defendant when he was staying with the aunt as a newborn. Absolutely no idea. Maybe it was the best thing that ever happened to him. Maybe if he had stayed with the aunt, life would be different. We have no idea. That's consideration. Now you have to decide weight. 0, none. Because you have no idea. How could something that could have been a very positive experience be mitigating? So you're going to go through that evaluation on all 54 mitigators. Once you are done, you get to step 4. You go to step 4 regardless of what happened on step 3, or step C, as it's in the verdict forms. Because even if you find that absolutely no mitigators have been proven, or if none of them have any weight, you still go to the next step. Because the next step is the weighing process. You now weigh the aggravators against the mitigators. The aggravating circumstances that have been proven beyond and to the exclusion of any reasonable doubt. In this case, you would have at most 6, because remember the 2 merge. And you would weigh them against the mitigating circumstances that have been found. And now you have to do a weight. Because how much weight are you giving the aggravators versus how much weight are you giving the mitigators? And it is absolutely within your discretion and within the law to say, even if you only, for whatever reason, found 1 aggravating circumstance, and you found all 54 mitigators, you can say, and it is within the law to say, that 1 aggravating circumstance outweighs all of the mitigating factors. But I submit to you that that's not what's going to happen. You are going to have found 7 merged into 6 aggravating factors. And when you do the weighing, the cold, calculated, premeditated nature, the heinous, atrocious, or cruel nature, his criminal history, those things unquestionably and beyond a reasonable doubt outweigh any mitigators you could possibly find in this case, or you could possibly give any weight to in this case. Now, when you get to this 4th step, you're back to the unanimous. All 12 of you that deliberate have to be unanimous that the aggravators outweigh the mitigators. If you find that the aggravators outweigh the mitigators, now you move on to the final step. Based on everything that you've been presented, everything that you heard in the guilt phase, everything that you heard in the penalty phase, everything that you've seen from the testimony and the evidence, the law, the arguments of counsel, will you impose the death penalty? You have to be unanimous. There are 2 lines. It says life or death. If you unanimously agree that the death penalty is warranted in this case, you check death. One of the things defense counsel is going to talk to you about is a concept of mercy. It is something that was mentioned in probably all of your jury selections.
Ms. Hicks?
Yes.
15 minutes.
Thank you, Your Honor. It is something that was mentioned 3 times. The word mercy was used 3 times in the opening statement of the penalty phase. The jury instructions will tell you that you never have to impose death, that you can always consider mercy. This is not a case that justifies mercy. The word mercy has synonyms. The word mercy, forgiveness, compassion, leniency, pity. These are words that should never be associated with this man. But more importantly, these are words that should never be associated with the torturous murder of Jennifer Fulford. The defendant made choices. He's made choices throughout his entire life that led to this day. He chose to go to the Walmart and buy the supplies. He had $500. He was homeless. He didn't have to spend $300 on cigarettes. He didn't have to buy duct tape and zip ties. He chose those things. He chose to sit outside the Berman house and wait for his opportunity. He chose to knock on that door. He chose to find her, to put her in the back of her car. These are all choices that he made of sound mind. He chose to take her to that field. He chose to wrap her head in the duct tape. He chose to stab her 7 times. These are all choices that he made. This is the man that he is. He chose to get caught. And he did it all so he could come in here and take that witness stand. You know that the things he rails about are not accurate. You heard from Mr. Estamera. This isn't about Julio Dominguez. That didn't even happen. These are all choices that he made so that he could accomplish his goal. Follow the law. Consider the death penalty. But don't just consider it. Find that the death penalty is the only appropriate sentence for the murder of Jennifer Fulford.
Members of the jury, in just a moment, we're going to take a brief recess. During the recess, you're going to leave your notepads and your pens here. During the recess, you're under all the court's instructions, including but not limited to the instruction not to discuss this case amongst yourselves or with anyone else. Please follow the deputy in the jury room. We'll bring you back as quickly as we can. Thank you. Be in a brief recess.
All right.
Please be seated. Thank you.
All right, so the judge just called a recess after that powerful closing argument from Kelly Hicks with the state. I still have my legal team with me, criminal defense attorney Sarah Becker and Tiffany Sibbons. All right, guys, I was writing notes upon notes upon notes. I mean, there was just so many gems and so many key highlights of Kelly Hicks's closing arguments, and she used that hour and a half that was given by the court so wisely. I think she really nailed certain parts. But before I go on my spiel, because I have so much to say about it, I want to get your thoughts. So Tiffany, tell me what moments for you were great in terms of Kelly Hicks's presentation to the jurors.
Attorney Hicks did a great job. I believe she did great with talking about the factors that were important. I think she did great with explaining those factors to just show that he needs the death penalty. Mm-hmm. When she said that this is a case that does not justify mercy, I agreed with that. He didn't have pity on Miss Fulford. He didn't have mercy for Miss Fulford. He didn't have compassion for Miss Fulford when he did this heinous crime. So they shouldn't give compassion on him. I think she did amazing. I mean, Miss Fulford, she's not here, affectionately known as Jenny Poppins. I mean, for a person like that, he needs to suffer.
Yeah. And Sarah, what are your quick thoughts?
The best thing that I think she did was balance the emotion and the intense facts of this case with the really complex legal base that the jury is going to have to apply. We heard her very clearly explain multiple different standards of review that the jury's applying, right? You've got beyond a reasonable doubt, you've got preponderance of evidence. Some factors have to be unanimous, others didn't. Death law is hard and complex. It's why as attorneys to handle these kind of cases, you usually have to be death certified. And I think that without confusing, she laid it all out for the jury.
She did. She did. We got to get a quick break in. I want to go ahead and still examine Kelly Hicks's presentation to the jurors that she just wrapped up. If you're just joining us, the state finished their closing arguments in the penalty phase of the Scott Nelson murder trial. And up next is the defense. So we'll get you right into court after recess is over with. So stay very close to Court TV. It's front row seat to justice.